Hello, my name's Glenn McGovern. I've been an aviation attorney for over 16 years and a pilot for over 11 years. In the course of representing pilots in FAA enforcement proceedings, I found there are two types of pilots: those who have been under investigation by the FAA and those who will be. Let's look at a recent issue of callback, NASA's newsletter regarding its aviation reporting safety system. In March of 1990, just 1 month, 3,024 mistakes were made by pilots who filed a NASA form to attempt to avoid a suspension of their license or a civil penalty. 2,099 were by air carrier pilots. 832 were filed by general aviation pilots. The current pilot enforcement system is complex, adversarial, and punitive. Pilots don't have a Bill of Rights. They don't even enjoy the same rights that citizens have in third world countries. They have no right to a speedy trial. The administrative action can drag on for years before a pilot even sees an administrative law judge. Pilots do not have a right to confront their accuser. Hearsay evidence is commonly admitted in proceedings. A controller's report or a radar operator's report may be admitted into evidence, thus denying the pilot the right to confront his accuser. There are no rules of evidence. The federal rules of evidence or similar rules of evidence have not been adopted in administrative proceedings by the Ntsb administrative law judges. Pilots do not have a right to a Miranda warning. They don't have a right to be warned before they make a statement to an FAA investigator. They do not have the rights that many citizens have. The present system is unfair. The FAA has a vast supply of experts, investigators, and administrative people who have but one purpose: to ensure the revocation or suspension of your license should the opportunity present itself by your allegedly or actually committing a violation. A pilot is never warned of this. A Miranda-type warning that other citizens are privileged to is not given to pilots. FAA investigators can proceed in an investigation and frequently do not identify themselves till it's too late for the pilot. A pilot may even be recorded while calling the tower, flight service station, or other FAA facility without any warning that the call is being recorded. Airman's Information Manual 4.4 provides public telephone calls can be recorded by ATC facilities, flight service station facilities, radio and telephone lines. Instead of a warning beep tone, only an obscure rule in the Airman's Information Manual, section 4.4, warns pilots who are only given notice by the Airman's Information Manual 4.4 entry. Recent decision entitled Administrator versus Reno sums up the real attitude of too many employees in the FAA. In that decision, an attorney with the FAA Enforcement Branch, Mr. White, at page 8, footnote 4, states as follows: "There's no such statement in our policies, handbooks, or anything else that says we should not take sanctions only for punitive reasons. We've been doing this for many, many years. All these cases have been tried. The sanctions that have been imposed have been for punitive, unless there's a question of qualifications, and that's another story." The NTS board responded that although they deplored counsel's erroneous comments, that they declined to overturn the administrative law judge's decision. When a representative of the FAA says something like this in an administrative proceeding with a court reporter present and in an appeal, it makes you wonder what representatives of the FAA say in private. A pilot and certain, but not all members of the FAA's perspectives on enforcement are often quite different. Joe Pilot may think all the Kinder Gentler FAA publicity is the reality. Certain enforcement personnel of the FAA, however, still believe that commercial and general aviation pilots are the true enemies of air safety. Perhaps the saddest casualty of this sort of mentality is a relationship that a pilot formerly had with an FAA inspector. The FAA inspector was looked at as a wise person who would be called on for guidance for guidance to help the pilot navigate through those inevitable gray areas of the FAR. This is a sad situation. Pilots who frequently find themselves involved in real, bona fide emergencies are often afraid to declare them for fear that they may be placed under investigation or called to take a competency check ride.
Alex, approach. I'd like to return to Alex. Request ILS 26. Circle to runway 8.
9 Golf. Any problems up there?
No problems. Just request ILS 26. 26 approach, and yeah.
9 Golf. Cleared. ILS 26. Cleared to land. Runway 8.
Roger. 99 Golf.
What's worse, a new trend may be developing, one that pits pilots versus controllers when altitude deviations occur due to the so-called computerized altitude deviation software called the snitch. In the shocking case of John M. Smith, Commerce Clearinghouse Aviation Reporter, Section 22851, NTSB Order EA 3648, in August 11, 1992, the Commerce Clearinghouse Reporter states that controllers lied giving a pilot a clearance. The administrative law judge found the controllers reported a deviation in order to cover up the trainee's error.
Roger. 99 Golf. Cleared from 8 to 4,000 feet.
The pilot was cleared to 4,000 feet from 8,000 feet. The controllers denied giving the pilot the clearance down to 4,000 feet. After a conflict alert went off, they immediately went down to the room where the recording equipment was located. They reviewed the tapes. The transmissions on the tapes were missing. There was only static on the tapes. The administrative law judge awarded the pilots $20,562 in attorney's fees, finding that the testimony of the controllers was contrived to protect a trainee. Unbelievably, the NTSB board reversed this decision and found that the FAA had reasonable grounds to pursue the enforcement action against the innocent pilot. The NTSB denied him attorney's fees even though there was only static on the tapes due to an alleged malfunction, and the tapes in effect were missing. There's another reason to fly using the defensive legal tactics I'll discuss with you in this video. Fact, the FAA prevails in an overwhelming number of pilot enforcement cases. Recent statistics from 1992 from the General Accounting Office regarding the NTSB show that the FAA prevails in an overwhelming number of pilot enforcement cases. Many of these are won by default or failure to meet deadlines, but the majority of the cases, the NTSB and the FAA win. 143 cases were affirmed, with the FAA issuing orders of suspension without modification. The administrative law judge modified FAA orders of suspension in approximately 60 cases. The administrative law judge reversed an order of the FAA in 32 cases. The total cases closed by initial decision of an administrative law judge were 235. In other words, the FAA won 61% of its cases. The FAA won most of what it wanted in 25% of its cases, and airmen won in only 14% of the cases. The source of these statistics are the NTSB 1992 statistics to the General Accounting Office. Airmen won only 14% of the time before the administrative law judges. Airmen won only 8% of the time before the National Transportation Safety Board. The best defense is to never end up in an enforcement action before an administrative law judge. The purpose of this video is to teach you defensive tactics to keep you from being involved in an FAA enforcement action. Now, you won't find the following tips in some of the alphabet aviation organizations' magazines or even in the FAA's aviation newsletter. That would ruffle too many FAA feathers. That's why we made this video for you. A pilot must take steps to protect him or herself in such a hostile aviation environment where the FAA is the adversary and is the source of the hostility. The purpose of this tape is to teach you legal defensive tactics to protect your pilot's license and your career. Never respond to a letter of investigation from the FAA. After an alleged violation occurs, a pilot will often be issued a letter of investigation by the FAA inspector. The letter will invite a response from the pilot. It's important to note that often FAA inspectors will downplay the seriousness of the offense and invite you to send a simple letter or statement to respond to the letter of investigation. Usually the FAA inspector needs more information to sustain the enforcement action.
Gotta respond to this letter, or else the investigation will proceed without the benefit of my response? Ugh.
Most pilots make the mistake of responding to the initial letter of investigation. Usually they provide information to the FAA which helps to prosecute them. This can only lead to further FAA enforcement action.
Now I've got him. Now I've got him.
You cannot talk or write your way out of being investigated when you receive an initial letter of investigation. If you receive the letter, you are under investigation. Fortunately, both the AOPA and the EAA have pilot advisory services. They can supply you with the names and addresses of pilots who are experienced in handling aviation cases. The AOPA even has low-cost legal defense insurance for pilots to help them bear the cost of an FAA enforcement action. The AOPA Legal Services Plan and the EAA can both recommend attorneys that are experienced in handling aviation matters. Do not make the mistake of hiring an attorney that's experienced in criminal defense or in probate. This can only lead to disaster. You need to hire an attorney experienced in handling aviation matters. Unfortunately, in various regions of the FAA, they have different rules and different ways of handling pilot enforcement cases. This is grossly unfair, but that's the reality. Your experienced aviation attorney will sit down with you, discuss the case, discuss your options, discuss whether you may pursue remedial training. If this is not pursued within a short period of time, it may be lost as a viable option. Your aviation attorney will be experienced and know the region that you're in and their rules and their ways, and will be able to advise you as to what action is appropriate. Your aviation attorney will also sit down with you and decide whether to respond formally or informally to the letter of investigation. He will probably draft a letter that responds to the FAA's letter and shows that you have a so-called good compliance attitude, but yet does not convey any information that can damage you or hurt your defense in your FAA enforcement action. Many times in a pilot enforcement action, the pilot in command or the exact identity of the pilot is not known. A pilot who inadvertently replies to a letter of investigation on his own without counsel will supply this information and thus give up a viable legal defense. Never give any potential violation-related information to anyone, whether in person, telephone, or in a recorded or non-recorded statement. Do not discuss the matter in person or over the phone with any representatives of the FAA. All representatives of the FAA, all employees, are duty-bound to report possible violations of the federal aviation regulations. Do not have any discussions either on or off the record, whether recorded or non-recorded, as notes will be taken by the FAA's inspectors of your conversation. This will be made part of your enforcement file. This takes loads of power on the pilot's part to overcome the intimidation that often arises in a face-to-face confrontation.
All right, I'd like to ask you a few fast questions about the flight you just took. Now, number
I'm
one,
not
can you tell
answering
me...
any questions. I have my AOPA insurance. I'm not answering.
So what was your point of origin?
I'm sorry. I'm not answering questions.
Well, now then, where were you planning?
Don't be intimidated. Be strong. You have no obligation to supply a statement at this point. Your pilot's license and your career is at stake. If a potential violation incident occurs, don't discuss it with anyone. Then tell your employees, spouse, secretary, etc. not to discuss any events of your life, itinerary, location, travel plans, etc. on that date. FAA inspectors will often attempt to obtain information from secretaries, line boys, employees at FBOs, or co-workers. It's important that you make known to these people that they have no obligation to make any statements to any FAA employees regarding your activities. For example, an FAA inspector may call Joe Pilot's office and speak to his secretary in order to establish that Joe Pilot was in New York City on the date of an alleged TCA violation. Information supplied by the secretary may enable the FAA inspector to prove a vital element in his enforcement case, namely that Joe Pilot was in New York City on the date of the alleged TCA intrusion.
Hello?
Was Joe Pilot in the vicinity of New York City on July 11th, 1993 in a Cessna 210?
Yeah, he was in New York on that day. Who may I say is calling, please?
If you are being accused of a possible violation, never call the tower or approach control with the phone number you were given.
November 9499 Golf, possible altitude deviation 8,000 feet. You may call Lakefront Tower Quality Assurance Office at 504-246-7878 during administrative hours for additional information.
Roger, 99 Golf.
Daddy? Are you in trouble?
If you call a facility, you will be asked to identify yourself. You will also be asked the make and model of your aircraft, your pilot certificate number, and you may or may not be informed of the exact nature of the alleged violation. Two things have been accomplished by this. One, you've been informed of the alleged violation, and then you can't complain later that you weren't informed of the violation so that you could take steps to protect yourself. Two, you've identified yourself as pilot in command of the aircraft and flying that particular aircraft on that day, and thus enable the FAA to have information vital to the prosecution of you in the FAA enforcement action. Prior to the time that Elizabeth Dole was head of the Department of Transportation, pilots were frequently told to call a tower or other facility and subjected to a severe scolding. Then, if the pilot was found to be a reasonable person, a repentant pilot, sorry for the alleged violation, that was usually the end of it. That's not true today.
Didn't your instructor teach you what a TCA is?
Of course I know what a TCA is.
Well, enlighten me.
Many a pilot thinks that he can explain away his actions and that the FAA enforcement action will go away at this level. Then what that pilot usually ends up doing is supplying vital elements in the FAA enforcement action. Remember, once your aircraft wheels are on the ground past the runway taxiway, the controllers have no more authority over you. You do not have to call them. You cannot get in trouble. You already are in trouble. Never argue with the controller when you make a mistake or are accused of making a mistake. Remember, all proceedings with controllers are recorded. If an error is made, do not argue with the controller over the air. This just takes up valuable air time and leaves a tape-recorded statement of the alleged violation. Also remember, if you contact anyone on the phone, flight service station, approach control of the tower, there are no beeping tones to warn you that your telephone conversation is being recorded and can be used against you in FAA enforcement proceedings.
Hi. This is Joe Pilot. The FBO manager told me you wanted me to call. Yeah. I just landed here 10 minutes ago. Yes. I am in Cessna November 9499 Golf. No, it's not IFR here. Yeah, it's raining cats and dogs.
Never confess and never say you are sorry or apologize if you make a mistake or are accused of making a mistake. You may at times hear a speech like this. November 9499 Golf. Confirm heading 280 degrees. Or November 9499 Golf. Confirm you just landed on runway 13 right, not 13 left. On November 9499 Golf. Confirm altitude 8,000 feet. When you hear a speech like this from a controller, your ears should be burning. Maybe what the controller is really saying is this.
November 9499 Gulf, you screwed up. Confess all your errors on tape for all the world so we can take appropriate enforcement action against you.
Do not admit your errors or say you are sorry. When controllers make a mistake, they don't apologize. They just file a NASA form, and you should do the same thing. Even if you have the slightest fear that you may be accused of a violation, file a NASA ARS Form 277 immediately. You have 10 days from date of the alleged violation to file this form. Often, the form will give you immunity from a suspension or from a civil penalty. The NASA form has two parts. The first part is called the identity strip. This part will be returned to you after you send the NASA form, and it's stamped with a date and time stamp on it. This portion is returned back to you, and the whole form is sent to NASA, not the FAA. It goes to NASA at Moffett Field. The second part of the form is information regarding the alleged violation or error. This portion of the form will be sanitized so as not to show your identity to the FAA and will be returned to the FAA, but it doesn't have the identity strip attached, which is returned to you. There's an interesting story behind the NASA form. Years ago, there was a commercial airliner that crashed. Everyone on board was killed. Before the airliner crashed, it was executed an approach with an instrument approach plate. The instrument approach plate was somewhat ambiguous. Prior to the airliner hitting the side of a mountain, there was discussion in the cockpit among the pilot and co-pilot as to whether they were cleared to descend at this point. They proceeded to descend and they crashed. Afterwards, the FAA investigators learned, after talking with numerous pilots, that they too had made the same mistake. They had gone below the minimum descent altitude inadvertently due to the ambiguous approach procedure. The FAA questioned the pilots and said, "Why didn't you tell us this? If you knew this was unsafe, why didn't you tell us?" The pilots responded, "What? And then I would be the subject of an FAA enforcement investigation?" The FAA at this point realized that safety was being compromised, that something had to be done, and that pilots did not trust the FAA. So it brought in NASA, and it started the very successful Aviation Safety Reporting Program. In exchange for pilots giving information on unsafe aviation incidents, they are given immunity in most instances for reporting their errors. In this way, an investigation can be made, statistics can be compiled, and unsafe conditions can be corrected by the FAA. Filing a NASA form will usually, but not always, give you immunity. Now, after you file a NASA form, the FAA proceeds with an enforcement action. They can still place a letter in your file notifying you of the alleged violation, but there will be no suspension and there will be no civil penalty executed against you. Now, there are some exceptions to this program. The exceptions are such as pursuing a criminal activity. You can't use a NASA form if you're running marijuana in your Cessna 210. If you do a deliberate act, for example, you buzz somebody deliberately, you will not be able to use the immunity of the NASA program. If you do an act which is reckless, you may not be able to fall under the immunity of the NASA program. But if you do an act which is careless, you will be able to fall under the NASA program. Also, the NASA immunity program will not work in an instance where pilot competency is at question. A photocopy of the NASA form will suffice. Or you can look at pre-1992 back issues of AOPA's Aviation USA. They have a NASA form in the back of those that you can Xerox and send in. You can also obtain NASA forms from your local FAA Gato office. Just don't tell them why you want it, or just tell them you want it for a friend. I recommend sending the NASA form by certified return mail. You can go to the post office and get your certified mail return receipt stamped by the post office. That will show the date that you mailed the NASA form. As I told you before, the NASA form has to be mailed out within 10 days from date of the incident. There's no limit on how many NASA forms you can file, but you are limited to use the NASA immunity program only once every 5 years from date of a violation. Keep some NASA forms in your flight bag and use them. Professional pilots do, and so do controllers. Don't leave a paper trail if a possible incident occurs. Don't incriminate yourself. Pay cash for fuel. For example, a fuel slip could be used as evidence that you were pilot in command of a particular aircraft on a particular day. It could also be used in an FAA enforcement case as evidence that you were below legal reserves on fuel.
Your 206 took 78 gallons of fuel? Man, you must have been running on fumes.
Thanks. I'm Fred Budensky from the FAA. I'd like a copy of that, please.
Don't log the flight in your logbook if a possible incident occurs. You only have to log the required flight time to remain current under the FARs. FAR 61.51 provides that you only have to log required flight time to show that you're current. Don't incriminate yourself by making a logbook entry if a possible violation occurs that could be used against you in an FAA enforcement proceeding. Never discuss the history of a flight with a stranger. Anyone asks about the history of a flight, don't discuss it. It frequently occurs that a pilot, unwary, is approached by a caring, friendly FAA inspector who fails to identify himself initially. Then after the pilot discusses history, the history of a flight, where he's been, what he's done, what plane he was in, then the FAA inspector will identify himself, and at that point it's too late. The FAA inspector has established the necessary elements to make his enforcement case. Don't talk to strangers is good advice for small children and pilots. Never surrender your license or medical certificate to an FAA inspector. Never physically allow him to take possession of your license. This may be construed as a legal tender of the license and a loss of appeal rights. You have to show your pilot's license and medical certificate to an FAA inspector, to an Ntsb investigator, and a lot of pilots don't know this, but you have to supply your pilot's license and medical certificate to a law enforcement officer if he requests it. Your pilot's license and medical certificate are required to be in your possession only when flying. If you're not flying and someone asks you to produce these, you do not have to produce them unless you're coming out of or near an airplane. Never allow the FAA inspector to ramp check or search your plane and check your logbooks. Let's talk about how to handle a ramp check of a non-Part 135 aircraft. In other words, a general aviation aircraft or a Part 91 aircraft. First, ask the inspector for his identification. If he does not produce his identification showing that he's an FAA employee, walk away. If he produces an identification, then you must produce your pilot's license and medical certificate. You also must produce the paperwork necessary to legally operate the aircraft, including the airworthiness certificate, your weight and balance material, your airplane operation manual, your placards, and the documents necessary to be carried in the airplane to legally operate an airplane under the FARs. If you're not a 135 aircraft operator and an FAA inspector asks you to ramp check or physically go inside your plane and check it out, you have no obligation to do so. Tell him you have to go to the bathroom and then just walk away.
I demand to inspect this aircraft now.
Oh, I'd really like to let you now, but I gotta go to the restroom.
Don't produce any logbooks or other aviation aircraft maintenance records at this time. If the FAA inspector asks to review these on the ramp, tell him you'd be more than happy to send him copies of the applicable records at a mutually convenient time. You're only obligated under the FARs to produce such records within a reasonable time. When you do produce such records, all you are required to produce is the records that go back to the last 100-hour inspection on a 91 aircraft or the last annual, not prior to that. Don't produce more records than you have to. Also, before you produce these records, go through them. Make sure that any alterations or modifications to the aircraft have the necessary forms and paperwork. Make sure all ADs are complied with. Make sure you've got your transponder tests, static system tests, and other requirements met so that you will not be in violation of any of the FARs. Also, if you're approached by an FAA inspector on the ramp and the plane has an obvious visible flaw, be sure not to operate that aircraft with that flaw, or you may be cited by the inspector for operating an unairworthy aircraft. Don't report an incident that is not an NTSB-defined accident and draw the attention of the FAA. Many times a pilot is faced with the difficult issue of whether an incident is in fact an incident or an NTSB-defined accident. Often, this issue can only be resolved with the aid of an experienced aviation attorney. If an NTSB-defined accident occurs, you cannot use the immunity that the NASA Form 277 would normally provide. It's also important to note that if you have an NTSB-defined accident, you must report it to the NTSB. The NTSB in small general aviation crash cases will usually refer it to the local FAA inspector and call the local FAA GATO office. Then the local FAA inspector will be sent out to investigate the general aviation accident. The FAA inspector now wears two hats, one of the NTSB safety inspector out to investigate the safety factors in an alleged accident, and two, he also wears the hat of the FAA as an FAA inspector out to look for possible FAR violations. 49 CFR 830.15a requires the operator of an aircraft to report an NTSB accident within 10 days of the accident. It requires a form to be filled out that is provided by the NTSB. Now, this is important. This rule, 830.15a, is not a FAR. It is not a federal aviation regulation. If you don't fill out the form within 10 days, you cannot be cited by the FAA for a violation of the FARs because it's not a FAR. It's in Section 830, the NTSB section. Also, it's important to note that when you file such a form, you are going to draw the attention of the FAA. So it's important to only notify the NTSB when you have, in fact, become involved in an NTSB-defined accident. Also note This is not Webster's dictionary definition of what constitutes an accident. This is Part 830, the NTSB definition of what constitutes an accident. And there's a big difference. Incidents do not need to be reported. Only accidents need to be reported. Now, let me repeat that. Incidents do not have to be reported. Only accidents have to be reported. Let's look at some examples of what is an incident and what is an NTSB defined accident. For our first example, let's take the case of an A&P who works on an airplane, does some mechanical work, intends to do some high-speed taxi tests. He does not intend to depart the airport. He proceeds to do work on a plane, does some high-speed taxi tests, and in the process inadvertently ground loops the airplane, doing damage to the prop by bending it, does damage to the skin by creating some small punctures, does damage to the wheel fairings, does damage to the landing gear. The question becomes, one, is this an NTSB defined incident or is it an accident? The answer is, it is not an NTSB defined accident. Since there was no intention of flight, the incident cannot be an NTSB defined accident. The A&P pilot in this instance does not have to file an NTSB accident report form. Here's another example. A pilot of a twin-engine aircraft suffers the failure of an engine, one engine, during flight. He lands without incident. Accident or incident? Under the NTSB rules, engine failure does not constitute an NTSB defined accident. If you suffer an engine failure, that's not an accident, and you don't have to file an NTSB accident report form with the NTSB. Let's take another example. A complex retractable gear aircraft is on an ILS approach to an airport. He neglects to put the gear down and makes a landing with the gear up and bellies the plane in the runway. Let's take another example. A pilot, after completing a flight in a Falcon jet, falls down the stairs. He herniates a disc in his lower back, requiring hospitalization within 48 hours, and he's in the hospital for more than 7 days. Accident or incident? Oddly, the answer to the question is that this is an NTSB defined accident. The moral here that is before you file that NTSB accident report that will possibly alert an FAA inspector, consult with an experienced aviation attorney and look very carefully at Part 830 to make sure you are required to file an NTSB accident report form. I may be criticized for some of these recommendations. I'm not advocating that any pilot at any time do anything to compromise his or her safety or the safety of others. I'm not advocating that any pilot report a false altitude or give a false N number or encroach on restricted airspace without permission. I'm not advocating that any pilot do anything other than take those necessary legal defensive tactics which we've discussed in this video in order to avoid the inconvenience and expense of litigation and protect the pilot's license and career. May your next flight be your best ever. I'm Glenn McGovern. So long.